A little bit about us before we get started. So Harbor Compliance is the multi-state compliance provider of choice for over 40,000 clients. We are a nationwide provider of registered agent, business registration, and licensed services and software. We also support the nonprofit industry pretty extensively, mostly through Labyrinth, which is our nonprofit brand. So today we're going to be talking about one of the buzziest topics in business compliance, the Beneficial Ownership Information, or BOI, reporting requirement under the Corporate Transparency Act. So a look at our agenda, what we'll be covering. First, we're going to start with beneficial ownership information reporting requirements, right? What are they? Then we're going to move into why maintaining BOI should be a priority for pretty much all businesses. And then we're going to take a look at what it takes to actually file a BOI report. And then finally, we'll just take a quick look at how to manage and simplify the BOI reporting process. So the presentation today will be about 45 minutes, followed by 10 to 15 minutes of Q&A. So if you have questions along the way, do drop those in the Q&A section. And we will have a little bit of time, hopefully, again, about 10 to 15 minutes to cover those at the end. And then finally, just a reminder that today's presentation is eligible for education credit through Earmark. So we will go over at the end of the presentation how to get your CE credit for that. Now, before we really dive into the presentation today, I do have a brief poll question to start off, just to really gauge how familiar you are with the BOI reporting requirements. So you should see that pop up on your screen in just a second. Awesome. So we still got some results rolling in, but everyone's pretty quick on this one, so I appreciate that. And so far, the results look pretty much like what we see on this webinar when we do it monthly, when we talk to other people in the field. We've got about 50 to 60% of people who say, I've heard of these requirements, but I don't know really whether they apply to my business. And then about a quarter say, you're totally unfamiliar, really here to learn more. And then the remaining 15 or so percent really feel like you've got a good grasp. So hopefully we'll kind of put that knowledge to the test through the presentation today, make sure that you kind of have a full understanding. All right, so now that we've kind of set a baseline, let's jump into it a little bit. So up front, just want to apologize in advance for all the acronyms I'm about to throw at you. This is a federal requirement. The federal government loves its acronyms, so you're going to hear a lot of them, but I'll do my best to kind of define them as we go so that it's as easy as possible to follow. So to start off, let's explain the why behind BOI reporting. So the whole reason that this reporting is now required is to accomplish the objectives of a law that was passed by Congress actually way back in 2021, and that was known as the Corporate Transparency Act, or the CTA. Now, the CTA was passed as part of the National Defense Authorization Act, and the primary objective here was really to prevent things like money laundering, terrorism financing, or other illicit financial activities, and to do that by essentially promoting transparency within corporate structures. So how does BOI actually support that objective? Well, by requiring most organizations to report information about the individuals who control their operations to the federal government. These individuals are known as beneficial owners, hence the term, beneficial ownership information reporting. Now, by revealing the individuals who actually benefit from a business, it becomes more challenging for criminals to operate businesses anonymously. You're familiar with the phrase, follow the money, right? BOI reporting allows the federal government to more easily follow the money and identify any potential bad actors behind really complex corporate structures. The agency responsible for this is the Financial Crimes Enforcement Network, or FinCEN, and they are a division of the U.S. Department of the Treasury. They've issued most of the educational information about the requirement, They've developed the filing process, and they also oversee enforcement. So you'll see on the screen a quote from FinCEN, which really describes how BOI helps to accomplish the purpose. So they say, BOI can provide essential information to law enforcement, intelligence, and national security professionals as they work to protect the United States from bad actors who exploit anonymous shell companies to engage in money laundering, corruption, sanctions and tax evasion, drug trafficking, fraud, and a host of other criminal offenses with impunity, while legitimate businesses suffer from their misdeeds. Now, while the CTA is a federal act and FinCEN's a federal agency, multiple states are actually actively considering or already enacting very similar requirements. For example, DC introduced a similar reporting requirement back in 2020. Both New York and South Dakota passed their own laws. California and Massachusetts are considering bills that would require additional state-level BOI submissions for entities that operate within their borders. So we'll focus on the federal requirement for today's webinar, but just want to make sure that you're aware that state-level requirements are on the rise, kind of mimicking this federal enact. So what is a beneficial owner? Well, to start, it's a natural person. Beneficial owners cannot be business entities. They have to be people, and that's really important. In addition to being human, they either exercise substantial control over a reporting company, or they own or control at least 25% of its ownership interests, or both. So the ownership test is really the easier of the two to understand. This is pretty simple, right? If you own at least 25% of a reporting company, either directly or indirectly, you are a beneficial owner. Substantial control is a little bit more nuanced, so I'm going to break that down a little bit. So substantial control exists if the individual, number one, is a senior officer of a reporting company. So that includes all senior officers like the president, the CEO, general counsel, COO, CFO, et cetera. But it's not just the title that matters, it's actually the work that they do. So even if someone's title is janitor, they can still be a beneficial owner if they perform functions that are normally reserved for senior officers. So if they do the work of a senior officer, their title doesn't matter. They're still going to have substantial control. The other ways that you can have substantial control, if you can appoint or remove senior officers, board members, members of other similar kind of overseeing bodies, that is substantial control. If you control important decisions about business direction or finances or legal structure of a company, or if you have any other form of substantial control over a company. And that last one is just kind of designed to be a catch-all so that unique or kind of creative control structures don't circumvent this requirement. Now, one thing to note is that if an entity was formed in 2024, you may also need to report information about the individuals who directly file the document that creates or registers the company. And if more than one person is involved in the filing, the person who is primarily responsible is usually the relevant party. That person is going to be referred to as a company applicant. And we'll talk a little bit more about company applicants in a minute, but they are very similar to beneficial owners. Now, a little bit of an aside on this new requirement. We've spoken with a lot of business owners about BOI reporting and about the CTA in general. There are two things that really stand out in the responses that we see. Number one is just how little awareness there is on the topic, right? Despite the fact that the reporting window has been open since January 1st of this year, most businesses, their owners have not been keeping up with these requirements. Back at the end of September, our team met with Phil Lamb. Phil is the beneficial owner and innovation chief at FinCEN. And he told us that about 28 million reports still remain to be filed this year, which would amount to over 250,000 reports a day from the end of September through the end of the year. And we've found there have been reports more recently that there's still, more than 20, probably 25 million reports that will need to be filed in the next, we're down to about 36 days here. So there is a ton of concern, right, about the lack of awareness just because of the volume of reports that still need to be filed. Phil actually told us that there is really no way to know for sure how FinCEN's system is actually going to hold up under the strain of these, tens of millions of year-end filings. They basically came out and said that their system would likely have outages toward the end of the year, and we've actually already seen these a couple of times on our own. But he did reiterate that the agency they're holding firm on their deadline. So whether or not there are outages, you've got a deadline and they're sticking to it. Now, the second thing that we hear a lot might actually help explain the first, and that's that business owners are really expecting accountants and attorneys to at least notify them of this requirement, and in some cases to handle it themselves. This is where business owners should really perk up and listen a little bit. In general, most attorneys and accountants that we've spoken to do not plan to offer BOI reporting services. And there are a few reasons for that, right? Number one, completing BOI reports involves the collection and storage of sensitive, personally identifiable information. And we'll talk a little bit about PII in a minute. Second, the ongoing need to kind of constantly update FinCEN with business changes, that presents a lot of complexity for an attorney or an accountant. So put together, it's a big technology challenge. It's a big security data risk that most firms don't want to deal with. And for a lot of them, this isn't just a matter of preference, right? These law and accounting firms have internal compliance protocols that really limit their ability to provide this service directly. Of course, these accountants and attorneys want to help their clients, right? They want to help meet this need. So a lot of them are partnering with third-party providers like Harbor Compliance, and we handle the filings on their behalf. And doing that really allows them to kind of educate their clients, right? They provide the information the way that their clients expect, but then they offer a solution that meets that need without having to kind of build a whole technology stack or touch the personally identifiable information that puts the firm at risk. Accountants and attorneys will definitely play a role in helping clients meet BOI reporting requirements, but for the most part, it won't involve kind of submitting those reports directly on the client's behalf. Instead, they'll be referring clients to partners to manage these requests, or in many cases, kind of working with those partners just to embed the technology in their processes, really to provide a seamless brand experience. So among the minority of business owners who are aware of BOI requirements, the big question, which we saw in our poll, is just, do these apply to my business, right? Are these requirements relevant for me? Well, we've seen a ton of hesitation from business owners who are kind of unsure whether or not this impacts them. To put it simply, 97% of all organizations registered in the US will have to report, right? That number is pretty overwhelming. Now, there are some exemptions for very specific types of organizations. There are actually 23 different exemption categories that FinCEN has created. But these tend to be really narrow, and they usually only apply to highly regulated organizations like banks or insurance providers, utilities, nonprofits that have a federal 501c or 527 tax exemption. Though it's worth noting that nonprofits that aren't federally tax exempt still generally have to report. The thought behind this is just that these organizations are already disclosing a lot of information to the government about their activities through license filings and other reports. So the idea is BOI really wouldn't reveal anything new that the government doesn't already know. So if you're wondering whether your organization qualifies for an exemption, we do have a free exemption quiz, which kind of helps you narrow down whether you are eligible. And we'll have a link to that in the email that you receive after the presentation, so you can take that quiz and get a better sense. There are a couple of niche exemptions that apply to really highly specific entities. But the broadest exemption that you want to be aware of is called the large operating company exemption. The large operating company exemption basically excludes entities that have at least 20 full-time employees and a US operating presence and a tax return reporting over 5 million in gross receipts. So those companies who meet all three criteria may not have to file BOI. This also applies to subsidiaries of those entities. That said, FinCEN has been very clear that trying to kind of consolidate employees across multiple entities to meet this threshold is not allowed. So if you own multiple entities, to qualify for this exemption, each individual entity has to meet all three criteria. So that brings us to our next poll question. So I'm going to pull up one more poll here, and I want to take a look at whether your organization might qualify for the large operating company exemption. So you should see the poll, and this has three questions. So first, it's going to ask if you have 20 or more full-time employees. Then we're going to look at, does your organization, did you report sales of 5 million or more on your tax return last year? And finally, does your organization regularly conduct business at a physical location in the United States? So I know that's a lot. I'll give you a second to kind of fill that in. All right, so we still got a few more responses rolling in, but we've hit a kind of a critical mass here. So if you answered no to any of these questions, you do not qualify as a large operating company for the purposes of BOI. You have to have answered yes, you do have 20 or more full-time employees. You did have $5 million or more in sales last year, and you have a US operating presence. If you hit all three, then that's a good indicator that you might qualify for this exemption. Again, it's worth verifying with an attorney. We're not providing legal advice here. But if you said no to any of those, you do not qualify for that large operating company exemption. So jumping back into our presentation here, assuming that, like most of you, you probably don't fall into one of those 3% of companies that are expected to be exempt. The first thing is just to know when your initial report is due. So you can see here the chart of due dates based off of when your business was formed. Put simply, at this point in the year, the time to act is now. As we sit here, there are 36 days until the deadline. And as you can see, for the first 9 months of the year, newly formed entities were the ones really facing a tight deadline. But now the paradigm has kind of shifted, and all impacted entities are really on the clock at this point. Note that starting next year, expectations really get even stricter. So beginning in 2025, newly formed or registered companies will have to submit their report within just 30 days. It is important to understand that BOI is not just like a one-time filing, right? This isn't one and done. Remember that BOI reporting, the whole point is to allow the government to more easily follow the money and identify any bad actors behind a complex corporate structure, right? Well, that's only possible if the information that FinCEN has is up to date. So that means that if any of the BOI reported to FinCEN changes at all, it has to be updated with them as soon as possible. Otherwise, their information on file quickly becomes outdated and, frankly, not that useful. Accordingly, FinCEN offers a couple of different report types to collect not just this initial information submission, but also updates or corrections. So updated reports are used to notify FinCEN of any changes to reported BOI. So think about making changes to an organization's name or registering a DBA, updating an office address, changing ownership, right? All of those trigger updated BOI reports. And those updates have to be filed within 30 days of that underlying change. They also offer a special category of updated report to allow an entity to declare a change in their exemption eligibility. So consider a nonprofit corporation. Maybe they form this year and they intend to apply for federal tax exemption. But the IRS tax exemption process can take a lot longer than 90 days, right? So that means that the nonprofit has to actually report BOI before the tax exemption is granted. And then once they become tax exempt, they would then file an updated report just to tell FinCEN, hey, we're no longer required to do this. We're tax exempt. We don't have to maintain updated BOI. Finally, FinCEN recognizes we're all human. We make mistakes. Sometimes honest mistakes happen when you're filling out these reports. So they do offer a corrected report, which essentially is to fix any inaccuracies in your previous filings. And again, entities have a 30-day window to submit that corrected report. And that starts from the date that the owner becomes aware of an inaccuracy. So you realize that you made a mistake. From that time, you have 30 days to file a correction. So technically speaking, it is possible for a business to only report BOI once, right? You form your business and then nothing ever changes. But that assumes that your business life cycle has no changes whatsoever. So the vast majority of companies are going to be filing updates at some point. So with all of that being said, I would like to open up one more poll question here. So I want to get a sense of whether you have filed your BOI report yet. And this is, again, a kind of multi-part poll here, but I would like to know, have you done this? What organizations have you done this for? And if you haven't done it, why not? What's the barrier or what's the reasoning there? So again, responses are still trickling in, but we've got enough to really start to see a pattern here, which is that basically 15% of the people on the call have filed BOI. The remaining 84, 85% have not. Again, that's pretty in line with the numbers that we're hearing from FinCEN themselves, right? I mentioned that only about 6.5 million have been done up to the beginning of November. That's out of an expected 35 million, 32 to 35 million. So it's a pretty small portion, right? Not surprised to see kind of the breakdown in the reasoning, with the vast majority of people saying, well, my deadline isn't until the end of the year, so I haven't filed it yet. Again, pretty common, not surprising. So I will jump back into presentation here, and we'll talk a little bit about those deadlines and how to approach them. So I mentioned earlier that there really have not been any extensions granted, and that FinCEN has pretty explicitly said, we're holding firm to the end of year deadline, right? January 1st is the day, we're not changing it. There is one extension that FinCEN announced, and this is the only extension that we have seen. A few weeks ago, FinCEN announced that businesses whose principal place of business was impacted by any of hurricanes Beryl, Debbie, Francine, Helen, or Milton might have an extra 6 months to file their reports, which on the surface is great, but even this is very, very limited and narrow. So first of all, it has to be the principal business location that was impacted. It can't be just any office or location. It has to be the principal. Second, that office has to be in an area that was designated by FEMA as qualifying for assistance. and by the IRS as eligible for tax filing relief. That's an and, not an or. So it has to be the principal business location. It has to be in both a FEMA and IRS designated area. And finally, because of the way that FinCEN kind of structured the timing of these extensions and the way that the dates of the hurricanes fell, most of them actually aren't relevant to the vast majority of businesses. So if you have a filing deadline at the end of the year, right, which was the vast majority of people on this call, meaning you haven't filed anything yet, but your business was started before the first of this year, so you've got that January 1 date. The only extension that might apply here is Hurricane Milton. Because the other hurricanes were earlier in the year, their extension window actually does not cover those for businesses that are due to file on January 1st. So what we're seeing here is even with this extension, FinCEN is being extremely narrow and very specific. If you do think your principal business location was impacted here and this might apply to you, we do have a blog post on our website, so I highly recommend you jump in there and take a look. It goes through this in a little bit more detail and can help you get a better sense of whether you may qualify for an extension. Okay, so next let's discuss just why this should be a priority, right? We have a lot of people on the call who said, well, I've got another month. It's just not a big priority right now. First, reporting under the CTA is the law, right? We've established that. And there's a big public benefit to that, right? Up until now, the US has actually really lagged behind the rest of the world in terms of corporate transparency. The CTA does a lot to kind of catch the US up to many other countries in identifying the legitimate owners of business entities and cracking down on some of these illicit activities. Just like a business files its tax returns and maintains licenses for its industry, BOI reporting is just another best practice in trying to kind of demonstrate good corporate citizenship. And if good corporate citizenship alone is not enough to convince you, you should be aware that the government has also introduced sticks in the form of fines and penalties to go along with this carrot. I did see that we have a couple of raised hands on the call. We are not enabling attendee audio to be able to speak, but if you have a question or a concern, drop it in the Q&A section. If we have time at the end, I'll cover your question, and if not, somebody from our team will reach out after the session and make sure that your question gets answered. So as I was saying, there's this flip side, which is potential fines and penalties, right? So let's dig into what some of these are. So as we covered, CTA has been lost since 2021. And despite that, most business owners really don't have an understanding of the requirements or how they impact their organization. BOI reporting isn't optional, and not submitting the accurate information in a timely manner really exposes businesses to pretty significant penalties here. So this alone has really moved BOI reporting to the top of a lot of company priority lists. There are two kind of distinct BOI reporting violations. The first is a willful provision or attempt to provide false information on a BOI report. This is lying, right? This is putting false information out there on purpose. The second violation is a willful failure to provide a complete updated BOI report. So this is avoiding the reporting requirement or not providing all of the information that you're required to. In either case, businesses can face civil or criminal penalties. As far as civil goes, violations can result in fines of up to $591 per day with a cap of $11,280 per violation. Those numbers were increased as of January of this year to account for inflation. FinCEN has said they will update annually, so we expect another update next year to reflect inflation there as well. And then with respect to criminal penalties, up to 2 years of imprisonment can actually result from one of these two violations. And note that this is not like an either or scenario. both civil and criminal penalties can be enforced simultaneously. Now, Harbor Compliance has been giving some version of this presentation on at least a monthly basis since the beginning of the year. And up until very recently, we've been telling people there are really two approaches to avoiding penalties. We used to say the best approach for most business owners would be to kind of closely scrutinize exemption criteria, define the beneficial owners for their entities. And that usually meant hiring an attorney to kind of make a legal determination of whether or not to report. And that would ensure that BOI was reported really only for entities that were absolutely required to provide it. That said, given where we are in the year now, there's really only one practical solution, which is to proactively report this information as soon as possible. Even if you have the money to hire an attorney to review all the details of your situation and give you an answer, it's unlikely that there's enough time to really conduct that full legal review. A lot of the attorneys that we have spoken to feel like they are drowning in these requests. They're just overwhelmed, and so they don't have the capacity to execute all of these reviews by the end of the year. So instead of risking it, business owners can immediately report BOI for all their entities that could possibly reasonably be impacted, kind of skip that paralysis by analysis and just take care of the risk, put it behind you as fast as possible. Now, keep in mind, there aren't penalties for submitting unnecessary reports. So if you think you might be exempt, but you aren't 100% sure, filing anyway is a really kind of low risk proposition. Then if in the future you find out you're actually exempt, an updated report can be submitted to kind of eliminate that need to maintain information going forward. So that second option is kind of behind us given where we're at now. All that being said, we do have a takeaway for everyone on the call today. This is kind of, think of it as your homework assignment, right? Bear in mind that maintaining legal compliance isn't just the law, it's best practice for businesses of pretty much all kinds. BOI reporting is a reality of just operating a compliant business. So your job immediately after this presentation is to take what you've learned and share it with your broader organization and ownership. As we've covered, it's an established fact. Most business owners just don't know about this. And they don't know about the risks or the penalties of failing to report. So don't let your organization fall into that category. Take this knowledge, share it internally, and make sure this is handled. For any attorneys or CPAs on the call, you may not need or want to be experts on the CTA, but your clients have an expectation and they need to know about the requirements. Certainly, we hope that this is giving you kind of a high-level information level that you can direct clients to find a solution. If you're like a lot of the firms that we work with, we'd be happy to kind of collaborate with you on educating your firm and your clients in a format similar to this one. So regardless of your role or your firm's position on offering a CTA solution, take the initiative, start the conversation within your organization, encourage everyone to educate themselves, and really advocate for prioritization of compliance. So before we jump into what it takes to manage BOI reporting, I'm going to launch what I believe is my final poll question here. So I appreciate your participation in these. So this last one is really about how you are managing this process today. So how is your organization currently managing BOI? Maybe you just haven't even started yet. Maybe you're in the process of kind of gathering all the information. Or maybe you're working with an accounting firm, a law firm, a service provider to kind of take care of this for you. All right, we're once again kind of hitting that critical mass, but if you haven't replied yet, keep them coming. So what we're seeing here is that about 60% are in the process of gathering all of this information with a plan to file the report, which is great to see. Another 30 to 33% haven't started gathering that information yet at all. And then a little bit, a few people here and there are working with a service provider, a law firm, or an accountant. So this, again, is pretty consistent with what we've seen. A lot of people who have not yet started gathering information. And we're going to jump back in and take a look at why that is not necessarily an enviable position to be in. So what does it actually take to report BOI? Well, we've kind of broken it down into 4 phases. You've got research, file, monitor, and maintain. And the first phase, research, actually has 2 parts to it. So first is determining whether or not you'll have to report BOI, which we've talked about a little bit. And second is just gathering the information needed to complete the report, which about 2/3 of you are kind of in that stage right now. So even though 97% of businesses need to report, there's still a lot of hesitation. Again, that recurring question, does this apply to me? Not to get ahead of ourselves, but I do want to call out the fact that we've kind of intentionally designed our service to allow those who are kind of pressed for time and just want to get this off their plate to skip this paralysis by analysis. We know a lot of business owners are getting hung up on exemption qualification. So we've included up to 4 filings per year in our service. So that includes initial, updated, and corrected reports. That means that we can take care of your initial report now. And then later on, if you find you're exempt, we can declare that exemption at no additional charge. Again, FinCEN does not penalize unnecessary reports. And then there's no fee for that additional corrected report. Now, all of that said, if you want to be sure that you're only submitting reports that you're absolutely required to, we also have a couple of helpful resources here. So the first is a chat with our brand new AI-powered chatbot, specifically focused on BOI. BOI Bot is a really strong tool, whether you're looking for answers about requirements or deadlines or compliance details. The bot can really help you navigate some of those complexities of the CTA. I do want to be clear, this is not legal advice from an attorney. This is intended as kind of general guidance. So if you would like to speak with the BOI bot, there is a QR code on the screen there. That will also be included in the email that you'll have after the presentation. Now, if you'd instead prefer to hear directly from an attorney, we can help coordinate that too. So another QR code here, this will take you to a web form where you can request contact from an attorney in our network. And then once you've kind of confirmed that your organization needs to report, you can start gathering the information that you need. So every organization must report 2 types of information here, company and individual. Company information is pretty basic. It's things like company name, address, formation jurisdiction. This information is very similar actually to what's required of individuals. So individuals will have to report name, date of birth, residential address, etc. Now, as I mentioned before, there are 2 different categories of individuals that can be listed here. You've got beneficial owners and company applicants. Beneficial owners are the individuals with ownership or substantial control over the entity. So we talked about that. Every report must include at least 1 beneficial owner, but there can be multiple. And actually, there's technically no limit to how many beneficial owners a single company can have. On the other hand, company applicants are individuals who either create or cause a company to be created. This is generally the person who files the formation paperwork with the Secretary of State and the person who directed them to do that. Company applicants only need to be listed for reporting companies that were formed in 2024 or later. So if your company existed before the 1st of this year, this may not be relevant to you. Each report can include up to 2 company applicants. But again, if your company is 2024 or later, at least 1 company applicant is required. And just a quick aside on FinCEN IDs. We've heard this talked about and asked about a lot. FinCEN can issue an ID number to an individual or a company. that ID number can then be entered into BOI reports, kind of eliminating the need to retype their specific details for each filing. Saves a lot of time, especially for clients with multiple entities or beneficial owners. So if that's something that might apply to you, it could be worth looking into getting a FinCEN ID before filing these. Now, at first, gathering this information for a BOI report seems pretty simple, but there is more to it than meets the eye. So before you reach out and start collecting information from your owners and applicants, a couple things to consider. Number one is the security of the data you're collecting. And number two is the time you have to invest to collect it. So first up is data security. The residential addresses, the images of government IDs, other personal details required in a BOI report constitute what's called personally identifiable information, or PII. You need to have certain security protocols in place when transferring or storing PII to prevent the sensitive information from kind of falling into the wrong hands or being intercepted, right? Just emailing or texting PII or storing it in a shared document is not considered secure. And that can be a real risk to your business. So believe me, you don't want to invest in creating a whole secure private environment to collect and store this information when you could save yourself a lot of time, effort, and money by working with someone like Harbor Compliance. Our information collection process includes all the necessary protections to allow you to kind of confidently request, store, and maintain sensitive PII. So now let's look at how much time you'll invest in collecting this information. FinCEN estimates that completing a single BOI report will take about 3 hours. Based on their recent presentation, it's clear that that was a little bit over-optimistic. They mentioned that many businesses actually took 2 to 4 months to collect all of the required information. So the time to start this process is now. If you're dealing with multiple entities, this message is even more urgent because we don't have 2 to 4 months anymore, right? We've got 36 days. Now, let's kind of walk through this. Imagine being an admin at a multi-entity organization who's responsible for reporting BOI. CEO tells you, gather everything you need for all of these entities under this parent company umbrella. Now you have to navigate the ownership and management structure for each entity. You've got to find the right individuals, locate their contact information, contact them all by phone, not email, to protect that PII. And then you have to field all their follow-up questions about why is this necessary? What is this information being used for? And that's all before you actually start filing anything. My point here is that Harbor Compliance's system saves a ton of time by allowing you or your admin to send dedicated information collection forms to each of these individuals. The approach keeps data safe. It avoids PII being shared in email where it could be intercepted. You just enter the person's email address, and our system goes to work collecting that required data. And since it's our system collecting the data, you don't have to worry about contacting anyone to explain what a BOI report is or why the requested data is needed. The system's interface, the notifications, it handles all of that and explains it in plain English. Now, not to mention our information form is just easy. It provides a really user-friendly experience with helpful explanations, intuitive design. So once you've run the gauntlet of collecting all that information securely, it's time to access the FinCEN Beneficial Ownership Secure System, or BOSS portal, and it's time to file. Now, in our experience, the BOSS is, honestly, it's fairly usable, right? But like any piece of technology, it's got imperfections. The main one for the BOSS system is that it tends to time out if a report isn't completed quickly enough. So if you put yourself back in that admin's shoes, imagine getting 3/4 of the way through a 58-question form and then being asked to take care of some other task, respond to an email, and then you come back to the form and the system's timed out and you've got to start from square one, right? Not a fun time. One of the many benefits of working with Harbor Compliance is that we insulate you from having to actually work with the FinCEN system directly. So that avoids you and your staff dealing with all these kinds of inconveniences. And a quick aside on FinCEN's API, FinCEN does offer a publicly available API that users can use to kind of pass BOI information directly into their system and sidestep the manual data entry. If you have the technical knowledge and know-how to connect it, theoretically, it makes filing a lot faster for large volumes. But very few firms really want to invest the time and effort required to do this connection. Harbor Compliance is an approved FinCEN BOI filing partner, so we're able to take advantage of these advanced reporting capabilities. And when you're working with Harbor Compliance, you can rest assured you're working with the most advanced approaches to information collection and transmission out there. While we're completing the reports on your behalf, you can maintain visibility into our progress with an easy-to-use project status screen, so you can communicate with our team of experts responsible for submitting your filings. But the most important benefit is how your data is organized, right? We store everything centrally, so it can be readily accessed across multiple reports, regardless of how many BOI reports your organization needs to submit. Each data point is requested only one time. And if you're a direct client, you provide the details for each of your reporting companies one time via our web-based information form, right? Each of your owners and company applicants receive their own customized form in their inbox, which again, they only fill out once. And if you're a partner with Harbor Compliance, it's even easier. So you securely send us a bulk file with your client entities and their beneficial owners and company applicants. We import that into our system and send the individuals their own information collection forms. So your reports are prepared on your behalf, eliminating the need for you or your clients to kind of key in the details multiple times across multiple entities. And that brings us to Monitor, right? I can't stress enough the recurring nature of BOI. This is not one and done. In practice, you're basically going to need to take a screenshot or a snapshot of whatever data you report to FinCEN. You've got to share it with all your beneficial owners and take time to routinely review all that information to make sure you catch changes as early as possible. You're basically building a whole new business process to monitor aspects of your beneficial owners' lives that you may never have been privy to before. And you'll need to start proactively asking beneficial owners if and when they plan to move residence or change their name. So it really becomes complicated. And monitoring doesn't stop with just individuals, right? You have to be in close touch with anyone that makes changes to your company level details. Is your business moving offices? Are you planning to register a new trade name or rebrand? Planning to sell an ownership stake to raise funds? All of those will be an updated report. And monitoring also extends to the requirement itself. So maybe you've heard about the challenge to the CTA in Alabama, which was brought by the National Small Business Association. Maybe you've heard about the recent ruling by a federal court in Oregon that upheld the constitutionality of the CTA. Both cases are being appealed, but in their recent presentation, FinCEN was pretty clear. This will almost certainly not be resolved before the January 1 deadline. Certainly, there might be future legal challenges that will impact the reporting requirements, but you'll also need to stay on top of any new requirements or guidances or copycat legislation at the state level. When you work with us, you'll be able to see all the most recent information right in your client portal. You can easily and securely collaborate with all your individuals, and you'll receive automated reminders to check in with key stakeholders. You benefit from our close monitoring of FinCEN and state level requirements. You saw this with the hurricane extensions. There are always changes happening. Our job is to stay on top of them for you. And finally, you actually have to act on the changes to all that data that you're monitoring. You have to submit these updated and corrected reports. Both must be submitted within 30 days of learning of the underlying change event, right? Failure to do so risks all the same penalties as not submitting the initial report on time in the first place. This, I think, is where Harbor Compliance really shines. Not only does our BOI reporting service include support for up to 4 initial updated or corrected reports per year, but the data that we store from your reports is processed by our compliance core algorithm. And as a result, we have actionable insights into what you need to maintain, not only your BOI reporting obligations, but kind of the bigger good standing of your legal entities, business licenses, tax registrations. And with the power of Compliance Core, we're right here to help you navigate over 22,000 filing requirements nationwide. So what does it actually take to manage BOI reporting compliance? Well, in theory, you could invest time building systems and processes to securely gather and store all this information. You could prepare the filings all on your own and muddle through the BOSS portal filing process. You can set notifications to track changes to the reported information and the filing requirement itself. You could budget the time and resources to complete updated and corrected reports every time something inevitably changes. You can build all these cumbersome processes right into your daily routine. Or you can lean on Harbor Compliance to just take care of it. So that concludes our presentation. We do have about 8 minutes for questions, so I'll jump in there. But as I mentioned at the start of the presentation, this is eligible for continuing education credit through Earmark. You can use the QR code that's on your screen. That'll help you download the Earmark app. And then after the session concludes, we'll email out a 5-question quiz. Once you complete that quiz, you can receive your CPE certificate. So I know we don't have as much time for questions as I had hoped, but I do want to jump into some of the questions that we received over the course of the presentation. So let me dig into these a little bit. This is a pretty good one. If my company is owned by a parent company, can I report the parent company as the beneficial owner? The answer to that is no, because a beneficial owner has to be a natural person. Companies cannot be considered beneficial owners. That's something that FinCEN has been pretty strict about, and they've reinforced in all of their updated FAQs and things like that. So a beneficial owner has to be a human being. Do you have to report your directors or officers' home addresses in your BOI report? Basically, yes. So a BOI report asks for a residential address. You are required to fill that in. On top of that, there is also a requirement that you provide an image of a government-issued ID, like a passport or a driver's license. So even if a filer puts, they don't want to provide their home address, they put in their business address in that field, it's still going to be listed on their ID. So yes, you do have to report the home address for those beneficial owners. Let's see, what else do we have in here? I'm an LLC with no employees. Do I still have to file? Yes, basically yes. On its own, the number of employees doesn't impact whether or not you have to report BOI. If you have a registered business like an LLC, you are covered by the CTA and therefore BOI requirements. The only time that the number of employees becomes relevant is the large operating company exemption that I talked about earlier, but that also comes with the requirement for your $5 million in business and a US business location. So again, employee count on its own does not impact whether or not you have to file. Let me see what else we have here. Here's one about the ownership threshold. So what if no owner owns 25% or more, right? What if you have a lot of owners? For easy math, let's say you have 10 owners and they each own 10%. Does any of them still qualify as an owner? The important thing to remember here is that there it's not just about ownership, it's also about control. So we have both the ownership threshold and substantial control. So if no one owns at least 25%, you have to determine who has substantial control. And again, that can be based off of the work that they do, if they are a senior officer or they do the work of a senior officer. If they are allowed to appoint or remove senior officers, board directors, similar kind of controlling bodies. If they control important business decisions, like financial decisions, kind of business strategy or structure, those will all still count as a person who has substantial control, which means that they are a beneficial owner. So the 25% threshold is one way to qualify as a beneficial owner. It's not the only way. Someone asked about if they already filed a report and they didn't list a DBA, can they correct the report? Yes. So the corrected reports can be filed through the BOSS system if that's where you initially filed your BOI report. But third-party services like Harbor Compliance also offer corrected reports if you filed through an attorney or an accountant. They can also provide that service for you. So you can absolutely go back and issue or file a corrected report there. I think we have time for one or two more questions here. Here's a question about state level. So do all states require this, or is it only based on the state your entity was created? Again, BOI is a federal requirement, so it's not state specific. If your entity is not part of those 23 really narrow exemptions, you do need to report BOI regardless of your state. But there are also those state level requirements that I was talking about. So far, only New York has actually passed that new requirement, but others are on their way. So that is kind of the state level portion, but BOI overall is a federal requirement. It does not matter what state you're in. You do have to follow the guidelines, and if you're not otherwise exempt, you do have to file. Here's one. We created an entity in 2024, but we were unaware of the 90-day filing requirement from the date of formation or registration. Is it still possible for us to submit the filing now? The answer is yes, and that you should absolutely do that. So even if you're past a deadline, they're not going to shut you off and say you can't file this. You're still able to submit that filing, and my recommendation is to do that as quickly as possible. We have not seen FinCEN actually implement any fines or fees yet, but there's no reason to believe that's not coming, especially with the wave of deadlines at the beginning of the year. So if you know that you have missed a deadline, the best thing to do is to just go ahead and file now. There's probably a fairly low probability that they would retroactively impose fines, but absolutely take care of it as soon as possible. That kind of takes us to the top of the hour. So I know that there are plenty more questions here. We have a great team on our staff who can reach out to you with answers to these questions. So keep an eye on your inboxes, and we will try and get those answers to you as soon as possible. But in the meantime, just want to say thank you, everyone, for joining, for your great questions, for participating in all the polls. Fantastic audience. It was great to speak with you. And we hope that you learned quite a bit about BOI and have clearer next steps, especially heading into the end of the year. So thanks again. We will be doing this webinar again in December. So feel free to join again if you have more questions. But you will receive a recording of it shortly via email. Thank you all. Have a great day.